Hi friends from around the world. I will give you a very instructive case, not very complicated today, but very instructive with regard to the classification of goods and genuine use. I will come to that in a moment. What we have here is a case of Monster. The Monster case, so to say. Monster Energy is a company from America, Californian company, who is selling energy drinks and coffee-based beverages and so in cans, right? So small cans. And they applied for a European Union trademark at EUIPO in November 2010. November 2010. They applied for one mark Monster, a word mark Monster, for goods in class 30 and 32, and a second mark some days later, Monster Energy, again word mark, for goods in classes 30. So the goods in class 30 are coffee-based beverages, and the goods in class 32 were energy drinks. So far so clear, no problem, right? Now, this was registered, no objections from the examiner, etc., no opposition. This was registered on the 19th of April 2011. 19th of April 2011. Now, on April 2017, a Swiss company, unrelated, I don't know why, they filed a revocation claim at EUIPO, at the cancellation division, against both marks, the Monster and the Monster Energy marks, right? So they alleged non-use. You know the use requirement already. So there's a grace period of 5 years, but beyond the 5 years, you need to prove the use of the mark. So the previous of the 5 years. How do you count this? Well, you have the filing of the revocation claim for non-use, right? That was in that case in April 2017. So from that onwards, you calculate 5 years back. And if it has not been used during that 5 years, so there is what the trademark owner has to prove the use. Okay? Now, what happened in this case? Well, the cancellation division, they saw the evidence of use which had been provided by the trademark owner, by Monster, and there is some evidence of use, but not evidence of use with regard to goods in class 30, so the coffee-based beverages. They were used for energy drinks. So what can be proof of use? What is it normally, what you find as an examiner for proof of use? What kind of documents you find? Well, typically what you find is invoices. What you will find is delivery notes, advertisement, brochures. You would find this kind of documents, affidavits from persons from the Chamber of Commerce, probably. So you can find all kind of documents. There's no exhaustive list of what can be filed as evidence, so everything has to be taken into account. And then afterwards, you have to look at genuine use with regard to token use, which is not an issue here, but that can be an issue in genuine use. So the token use would be very small in its kind, and is not really with the purpose of getting a market share, but just to show, well, I have used something. So this is with regard to the genuine use. I want to make the point here in order to get you to the practice in Europe. So they filed some use for energy drinks, sufficient use for energy drinks, but the cancellation division found that this cannot be used as proof of use for the goods which were in class 30, so the coffee-based beverages. Thus, consequence is that the first trademark is cancelled with regard to the goods in class 30, and the second trademark is fully cancelled because they had nothing to do with energy drinks, and class 30 was not proven, so it was cancelled. Monster, as you can imagine, was not happy with it. It went to the General Court, to the Boards of Appeal first, which confirmed, and then it went to the General Court. Now, the General Court decided in 2021, in November, on the case. And there is some background with regard to the, or no, let's come to the arguments of the Monster. What does Monster say? Well, Monster say first that the Boards of Appeal did not take into account multi-purpose goods, multi-purpose functional goods. There was a previous case from the Boards of Appeal in which the Boards of Appeal admitted injection pen with adrenaline for goods in classes 5 and 10 at the same time. So here we have that is the allegation. We have the purpose of coffee-based drink and energy drink. So this is a multi-purpose good here. What has been proved as evidence for genuine use, and it should be recognized by the board to be proven in both classes, right? That is one argument, and the other argument is that the can in which the energy drinks or the coffee-based drinks are presented, they have a clear indication of a coffee on the front and on the back. On the front, there is something which espresso coffee, and on the back there's also coffee-based coffee-based beverage, and there is as ingredient coffee only 1.3%, but still as ingredient coffee is indicated on the can. Now, what does the General Court here said? Well, it went on to say what happened with the NIS classification. And it is about the NIS classification. What you know as a lawyer, as a proficient lawyer in IP law, that the NIS classification has only administrative purposes, meaning that if you compare one kind of goods in one class and another kind of goods in another class, it doesn't mean that they are dissimilar being in different classes. No, it is about all circumstances of the channel, the nature, the purpose of the goods, etc., which determines whether there is similarity or not. So for the kind of comparison, the NIS classification has not really a determinant factor. Now, for the classification, that is a bit different. It has administrative purposes, but it is different in the sense that there are general principles. So if you have looked once into the NIS classification, I think you have looked many times into it already. So in the general remarks, it is said that each good has to be classified according to its purpose and function in one class. And there are, there are 45 classes. We have 34 in goods and 11 in services, right? So the general principle is one good in one class. There may be a specific situation where you have multi-purpose goods, but multi-purpose goods are goods which have different components and can be used or can be function in one or in the other. So these different components are a bit distinguished from one another, although they are part of the same good. If you want to, they are sold together and they are fixed together probably as well. So in this case, this is not the case. We have one homogeneous good, which is one drink and one can. So there's nothing which can be discerned, which can be separated from one or the other. So there is only one good, one homogeneous good, and it can be classified only in one class. Now, which class is it? And this comes down to what is the purpose and the function of the goods which have been sold and which evidence has been presented and which have been sold on the European market. As to the reference of Monster, what is the coffee? The coffee on the front and the coffee on the back. Well, the coffee on the back is very small as ingredients, you know. If you want to read on the cans what is in the ingredient, well, I'm not able to read it. It is so small, so it is very difficult to get to it, and you cannot give it a dominant argument, prevailing argument on it. Now, the quantity of coffee in these drinks is only 1.3%, so that is not very much. And the boards of appeal, they stated already from the outset that many of the ingredients are typical ingredients of energy drinks. So it was not really the purpose of the goods to be coffee-based drink. So 1.3% in any way is very, very low. So if one has to choose between one and the other class, the 30 and 32, it is clear that the proof of use of these goods, the purpose of the goods is energy drinks, and they cannot be cannot be classified under coffee-based drinks. And the fact that the Nice classification make this difference between coffee-based and the energy drinks, that is different, although the coffee, well, it gives me energy in the morning, every morning, but, it is a different classification with regard to the purpose and function. This is now the difference and the importance of the Nice classification with regard to once classified, and this combined with the proof of use, I think it was very instructive. For the practice, well, you know what the importance of Nice classification can be once you apply for certain goods and others not. You need also to know, and you know already, what is that you have to prove the use of the goods at a certain moment. So file only for goods if it is important for you, for which you will also be able to use, to prove the use, and the kind of documents, what is being required in Europe for the administrative or the judicial instances, what you have to present as proof of use. So there's no exhaustive list. Everything that can be helpful for proving the use of the mark, it can be also accepted. It must be more than genuine use only, right? So thanks for this case.